All right, let me make sure we got everything tied up here. I think that works now. Put it here. Make sure we're balanced.
All right, let's jump right into it. Thank you all for joining us here today. I'm happy to welcome you all to FIU Law's first ever Sports Entertainment Fashion and Art Law Society Symposium. My name is Josh Goldberg. I'm the president and QL of SEFA. We have an amazing week planned, so I hope if you join us here today that you join us throughout the week for our other panels also. Today, we're excited to kick off the week with our discussion on name, image, and likeness. I'd like to introduce our four panelists. We have Casey Schwab, who is the CEO and founding partner of Altia Sports Partners. Kevin Kendrick, who is the Associate Athletic Director of Compliance at FIU. Blake Lawrence, who is the CEO and co-founder of Open Doors. And Keone McGee, who's the Miami-Dade County Commissioner for District 9 and also helped write Florida's name, image, and likeness bill. So thank you all for joining us here today. We really appreciate your time. My first question that all of you guys can answer is, in this past week, the hashtag not NCAA property has been trending on Twitter with many college athletes speaking out and demanding that they be able to be compensated for their name, image, and likeness by July 1st, which is when Florida's NIL bill goes into effect. What is your take on these events that unfolded this past week with athletes advocating for themselves?
Josh, I love it. I think it's a great opportunity for individuals to express their displeasure with what the NCAA has done to them for over 100 years. We're talking about billions of dollars that have been taken away, income-producing activities from these students. Josh, let's be absolutely clear. What the NCAA has done to our students and our athletes have basically created an unfair system. So basically what ends up happening is you walk into a classroom on a college campus and you have a student there who's let's just say on the art scholarship. That gentleman or young lady can actually go out and sell her art and make money and use that money to actually provide for their family or provide for themselves. And then you have another student who sits directly next to that student in the classroom who's an athlete. That athlete cannot even allow for someone to buy him a bowl of noodles and cannot even help the local mom and pop businesses achieve their true potential by advertising for them with their name, their image, or their likeness. And that was the genesis of the bill. And this is something that I'm so happy to see, hashtag not NCAA property.
Yeah, I would actually jump in and agree 100%. What you've seen over the last week, one, I think it could not have been the timing was perfect. The week of the start of March Madness, what you've seen also in recent years, this goes back to, I can't think of the player's name, last name Shabazz for UConn, when they won the national championship. Mm-hmm. A comment he made during an interview indicated that he went hungry. He had no food to eat. And that is what launched eventually the cost of attendance legislation. And obviously it launched the discussions of what we're having now. I'm fully in support of all of our student athletes. I think also what you have is a discussion that needs to be had amongst all institutions, not just in the state of Florida that regards student athlete health and safety. And what they're doing, they're voicing their opinions, they're talking about their experience. And I think that needs to be at the forefront of all discussions when we talk about this legislation related to our student athletes.
I think this is an example. This campaign shows the power of the student athlete's voice today. If you go back to the moment where the NCAA said that we are considering some reform to the NIL legislation, until today, there has not been an NCAA tournament to put all the eyes on the student athlete and give them a chance and a channel to share what they believe is going to be the big shift in NIL legislation, which is giving the student athletes their rights to monetize their name, image, and likeness. And by all intents, I believe that those efforts are going to align with what the student athletes want and terms of next year being able to monetize their name, image, likeness rights. And much of that is due to the speed at which the state of Florida was able to move with their NIL bill. So I think that all of this is actually probably the first time since the NCAA said outwardly that they plan on making wide sweeping changes to NIL legislation, that student athletes have had March Madness in this stage. And it just doubles down and emphasizes that today's athletes can use social media, digital media to draw attention to things they care about. This is the perfect example of the power of student athlete NIL rights. And it's not just for the not NCAA property hashtag, but also what happened with the NCAA women's championship and the weight room, and so much of the change that's happened over the last week there. So this is an example of what's the future looks like when student athletes are taking control of their voice and their narrative.
Yeah, and I agree with all the fellow panelists, and kudos to you, Keone, for being ahead of it down in Florida, because as Blake said, Florida's obviously first, and we're seeing these other states move, but it's one of these factors, one of these situations where being first is the hardest, right? The jump from 0 to 1 is significantly further than the jump from 1 to 2, and then 2 to 3, and it gets smaller for each state. So kudos to everybody down in Florida who worked on that. Kevin made an interesting point that I want to like double down on, which is it's the institutions, it's the coaches, it's all the stakeholders involved. I think that one of the interesting narratives is, where do the institutions sit? Where do folks like compliance folks like Kevin sit in this? Because there's this tug of war, right? Between, hey, we don't want the institutions who are part of the overall management side, right? If you think about professional sports, you have management, you have labor. Technically, the institutions are kind of like management, but on the other hand, the institutions are the ones that are on the ground floor. Folks like Kevin are working with the student athletes day in, day out. You don't have a players union in college. So I wanted to emphasize, I thought it was interesting what Kevin said. I think all the stakeholders need to come together and say, like, look, what is what makes sense? What's a practical framework for these student athletes to, one, like Blake said, share their voice, the power of their voice, and have a platform to do so. But two, to go out and make some money, to go out and make some money, but to do so in a way that puts them on level playing field with their classmates. Like Keone said, he said it really well.
So when discussing name, image, and likeness, there's the argument about amateurism always gets brought up. And next week, the Supreme Court will hear the oral argument for NCAA versus Alston, in which the NCAA is petitioning the Supreme Court to reverse the Ninth Circuit's ruling that the NCAA and its colleges have illegally conspired under federal antitrust law. The NCAA has said that if this is upheld, this holding, that it will destroy amateurism. Do you believe that this is the beginning of the end of amateurism? And what do you think?
Let me just say this. Anytime you are attempting to break the monopoly of a company that has had, let's be absolutely clear, the NCAA is a company that has held a monopoly for over 100 years and have gained billions of dollars at the expense of young men and young women who oftentimes, many of them are not going to go pro. They're not going to go pro. And I think there are some experts on here who will probably confirm that a lot of them are not going to go pro. And so when you have individuals who are swimmers, individuals who play other sports in school that are not football, baseball, or basketball, and they are at the end of the road, especially when it comes down to women, because there's not that many women professional sports. So then you get the NCAA pushing back against them wanting to make money while they're in their prime, and to claim that this will be the end of the glory days for them, to claim that this violates a common law on the books. The NCAA should be ashamed of itself. It should do what many have been calling for year after year, and that is to sit down with us. We've made numerous attempts to sit down with the NCAA to come up with a compromise that would fit both sides. They didn't want to follow. They felt like they had the upper hand. They felt like they had politicians in their pockets, and we chose to go the other way. That's why when I met with Governor DeSantis and we had that conversation one-on-one, we knew exactly what we had to do. Let's be absolutely clear. The NCAA is not in a position at this time to win. They're not. Why? Because California goes into effect in 2023. Florida goes into effect in 2021. And once you get Florida, California, and Texas to follow, it's done. It's a matter of time. So they're gonna push for every little step at this point to save their hold on this money, their monopoly. But I don't think in today's time, with the technology we have and with the pressures they're receiving and with the experts like you all on this phone, I don't think the NCAA is going to be able to hold on to that power much longer.
Yeah, what's really interesting about what Keone just said is, I like, my background is in law, and I worked for the NFLPA negotiating deals, right? And if you negotiate a deal, what you do is you're on one side, you disagree with me, right? The adversary, the person on the other side of the table. We disagree on, let's say, 5, 6, 10, 12, 40 issues. What you do is you lay it out, right? You lay it out in like a hit list of issues, and you say, okay, we're here, you're there. And then you go through each one. And then you go back to your corner, and you say, okay, these are the ones that are the most important to me, to us, to my organization. And then these are the ones that we can potentially give on. It's compromise, it's negotiation. Y'all are law students. It's mediation, right? It's like, whatever word you put on it, it's coming to the table, wide-eyed, practical, realistic about how you can get something done. And that just hasn't happened. It hasn't happened with the NCAA. And I look at this. There are currently 6 federal bills, as y'all probably know. There are a bunch of different state legislation. Most of the state bills are modeled after Florida. There aren't that many open issues, right? If the NCAA has now accepted, begrudgingly, they've accepted that they're going to embrace NIL to a certain extent, right? Once you get past that, you've got like 6, 7 issues that are open at this point. Make a list, sit down and figure it out. I really think if this was approached from a, if you had 2 private equity firms negotiating this would have been done a decade ago. Right? If you approached it like it was a business problem, I think it's doable. And frankly, Keone might disagree with me on this, but I think the amateurism model can be upheld. I think it can be withheld even under this construct of, hey, let's do what's right here. Let's name, image, and likeness rights. Let's figure out the intellectual property of the school. The corporate competitors or corporate partners. Let's figure all that out. But we can still have amateurism. We can still be short of pay for play, but get NIL out there so you get these student athletes on the same footing as other students.
Casey, as a matter of fact, my brother, I agree with you.
Good.
They can coexist.
Yeah,
but the adversary. I want to call them an adversary, but I want to call them the company that wants to hold on to everything. They're going to say that's their argument, right? And they're going to. It's a scare tactic. Look, they're about to lose possibly $7 billion.
But they're going to lose more. Like, not to interrupt you, but they're going to lose more, right? It's like, it's no different. It's the same reason why all these 90% of cases settle on the courtroom steps. It's the same thing for all the to-be lawyers out there, litigators out there.
Well, Josh, I'll add, obviously my background is coming, excuse me, from an NCAA standpoint. Ultimately, this is what it's all about, amateurism. Currently, as it stands, it's currently looking to amend the current definition of how we look at agents, how we look at amateurism. Can a student athlete agree? How would they agree with an agent or agree, orally to get into an agreement moving forward? So I'm not disagreeing with the other 2 individuals, but from obviously the focus here is on the state of Florida, but from an NCAA standpoint, we're still up in the air. But ultimately, that's what it's all about, amending the definition of amateurism, agents, and everything surrounding what a student athlete is restricted and would be permissive, permitted to do.
And Josh, I don't know if we're going to get into this. Another topic of this specific question is the Austin case, Supreme Court and whatnot. But one of the people that I empathize with most, and those that are maybe new to think about NIL are individuals like Kevin. I think that the opportunity for student athletes is undeniable. Okay, it is here to stay. It's coming, but the compliance burden that comes with opening up name, image, and likeness rights monetization is very, very real. I would say that Kevin gets a new rule every single year that he has to protect and defend his student athletes and help uphold the rules at FIU, but he does not get more resources, right? So more rules, no more resources. That is the name of the game of the NCAA compliance director. So I think that there is all of these opening up is just going to create an entirely new economy and additional challenges that come with it. And Kevin, I empathize with you as somebody that actually has to go through and make sure that student athletes are following whatever the new rules are.
Definitely. I'm going through the room and I see quite a few compliance colleagues, and I'm pretty sure they are feeling the same pain as you mentioned that. But one of the things that I've done here to prepare for name, image, likeness is just kind of mention the same thing you said. Obviously, the obvious thing here is name, image, likeness. You're pulling several individuals across the country in compliance offices away from their core duties. So the concern there, I think Josh may have mentioned it, how are we going to monitor it? How are we going to oversee it? Obviously, I don't know if we're going to get into the weeds of things, but obviously there's a piece of the name, image, likeness legislation that talks about disclosure. You know, who's going to be responsible for that? Will it be a conference thing? Will it be institutional? Will it be someone across campus? So it's a lot to figure out. Obviously, July 1 is coming up quicker than you know it. And obviously being in the state of Florida is an advantage, but obviously it's a gift and a curse as well. So what we know is the train has already left, whether we like it or not. So we just got to get ready and prepare to the best we can as an institution, as a compliance staff, and help understand everybody's role, not just within in the compliance capacity, but it will be a shared responsibility for the university as we protect our student athletes moving forward.
Keone, I know you have to leave at 1 p.m., so I want to direct this question towards you. I love your passion of what you're trying to stand up for student athletes. Why has this been such an important issue for you that you've been advocating for student athletes for so long?
Well, three reasons. Number one is a fairness issue. Look, I was a prosecutor here in Miami-Dade County for 6.5 years. And it bothered me to see some of the students athletes coming before the court, and I had to prosecute them. But, you know, when I sat down and spoke with them and found out what was the true reason, many of them did not have access to capital to sustain themselves while they were in school. They would go study and they would practice more often, 6-7 hours. They don't have time to really go out and get a job. And so when they come home, they're out doing things because they can't monetize their names. And so they would do things. It would lead to theft. It would lead to robberies. It would lead to other things. And I said at that particular moment, something has to be done. Secondly, it's just unfathomable that we would be in a capitalist society where we talk about free market, and you have individuals who are smart enough, number one, to get into a higher educational institution. Number two, to maintain their grades to stay there. And number three, but sitting there and it's sitting in a classroom knowing that you have the potential to monetize and participate in a capitalist society in a free market, and the same government that tells you and the same professor that's teaching you how to become a business owner and monetize yourself, yet one organization sits there and has enough power to create an unequal and unbalanced system against that individual. It was not right. And the last thing is, how would it make you feel? It's called empathy. How would it make you feel if you all your life, especially as a young woman, and I have 2 daughters, and I see this, and you are working your butt off to get into college and get into university and go pro, and you come from a family of modest means, and you're up there trying to make it, but at the end of the day, you and I both know that women's opportunity to get into a professional sport, it goes down as they age and as they prepare to age out of universities and colleges. So where does that leave them? So for year after year, they've been training since the age of 5 to own a sport, to do well, and they can't earn any money. How would that make you feel? And that's where the empathy comes in. So that's what it's about. It's basically those 3 points. And that's why I fight so hard for them.
You mentioned before that many student athletes, their best time to monetize themselves is during college. Blake, your company at Open Doors helps connect brands with college athletes. How do you think once name, image, and likeness is implemented, can student athletes best monetize their brand?
Yeah, and Josh, Open Doors is an athlete endorsement technology. We help connect brands with athletes and currently professional athletes. No, we don't currently, the brand connection side of our business does not work with student athletes, but as you can imagine, that's a flip of a switch. So, I guess, Keanu and for everyone on this call, I mean, I played football at Nebraska, right? I was a starting linebacker one day and woke up the next day knowing I could never play football again, right? I suffered 4 concussions in a little over a year and I was done. And so since that day, I've dedicated my career to helping athletes understand this doesn't last forever, to make the most of whatever window of opportunity they have. And I would say that there is undoubtedly this generation of student athlete has a moment in with social media and influencer marketing and creator monetization, all these online tools where this is the peak of their earning potential, or it's the beginning of a long career of monetizing their name, image, likeness offline. But I can tell you that the day that your career is done, that fan base and their attention shifts elsewhere. They shift to that new class, right? So there's an opportunity that if student athletes can, from the day they step onto campus, start to leverage that time to realize that what they say matters. The audience that they develop online is linked to their earning potential, right? When we talk to student athletes today, just in terms of education, we talk about the fact that your follower account and your bank account are linked, right? And if you can get more of one, you will get more of the other, right? As soon as these rules changes are in effect. And so the outstanding issue and opportunity for student athletes is to realize that they have this window, and most of them don't realize until it's gone that was it. That was all they get. And I think that the great part of this reform is going to be the student athletes are figuring that out day one. And this is going to be a big earning potential, 4 or 5 years for each student athlete, all sports across all levels of college sports.
You mentioned that Open Doors, they don't connect with the college athletes yet with the marketing deals, but you're already working with colleges, helping with social content. So for the future plans, are you planning on connecting deals with the school who will then give it to the athlete, or working with the college athlete directly?
Yeah, really with the athlete directly. So Open Doors, we provide technology to this athlete endorsement industry. And for the last decade, we've provided really 4 key tools. The first is a name, image, and likeness marketplace solution. So it is connecting brands with athletes. Then there's a marketing solution, which helps athletes build up their audience. Then there's a compliance tool, which helps the governing bodies get visibility into transactions. And more recently, an education product, which helps athletes understand their value. And so our role is really in providing technology to assist athletes to connect with opportunities that make the most sense for them and monetize their name and likeness in a compliant manner, right? There's a lot of rules that govern who can do what, where, when, and how. And so the opportunity for athletes is real, but the opportunity for them to say the wrong thing, wrong place, wrong time, and mess it all up is also very real. So it's important that there's compliance alongside the marketplace technologies that are going to prop up helping athletes to monetize.
Definitely. And I know, Casey, that your company is helping many universities transition with this name, image, and likeness. You guys have partnered with LSU, Texas, and South Carolina. What are some of the most common questions that universities ask you?
The biggest question is, where do we start? And so Blake and I were joking at the beginning, I've known Blake for a long time at the NFLPA, and there's this, a lot of folks in the market, meaning the schools and folks at schools are looking at all these different companies popping up, and they're going like, are they all competitors? Are they not? And really, we're doing something entirely different than what Blake at Open Doors is doing. What we're doing is coming in and saying, hey, look, we're going to be a white glove, a service coming in and helping. Where do you answer that question of where do you start? And it really starts with educating the administration. So I'm sure Kevin can attest to this. Everybody within an athletic department has their own lane. Everybody has their own job, and that's okay. That's how it should be set up. But everybody has different motivations when it comes to name, image, and likeness, and reservations. So typically, most of the compliance folks that we talk to, they get it. They get it. They understand the rules. They understand where we are. They understand what's going to happen, and frankly, what the challenges are. What becomes a little trickier is when you start talking to folks outside of the compliance world or the compliance department. And that's where we're starting to have those conversations. Then it gets even trickier yet when you start talking to coaches, because we all know what college coaches care about. It's one thing, recruiting and then winning, but it's recruiting, right? So coaches have a very narrow mindset when it comes to NIL, and that's okay. There's nothing wrong with that. But how do you have the conversation between the compliance group, the marketing group, the social media group, the coaches, and then most importantly, as we've been talking about, is the student athletes. So we're working with the student athletes at the schools you mentioned to literally sit with them and say, like, look, what are your goals? One of the things that we talk about a lot when it comes to name, image, and likeness is this is an opportunity to yes, build your brand, but to build yourself as a business, right? It's like the Jay-Z quote, like, I'm not a businessman, I'm a businessman. This is an opportunity for student athletes to learn about professionalism, to learn how to show up at an endorsement opportunity and shake hands and know the names of the people that they're going to meet, to create an LLC, to learn about taxes. I think Keone was mentioning most of the student athletes in this country don't play professional sports. All of the student athletes in this country at some point will have one thing in common. They will be a former athlete. Even if you go and you have a 10-year, 15-year career in the NFL or the NBA or the W, you will be a former athlete where you have to have a career, right? So this is a perfect opportunity, this name, image, and likeness era, for these student athletes to not only make some cash and to monetize their NIL, but to use it, right? And that's what we're doing, Josh, is coming in and saying, like, look, all right, cool. So you're a beach volleyball player and you want to start your own business. Here's how you can use your NIL for that. Cool. You're a men's basketball player and you want to be a DJ. Here's how you can turn name, image, and likeness, these new opportunities into becoming a DJ. And there's like dozens and dozens of those examples.
Josh, I'm going to jump in. First and foremost, I appreciate Blake's information that he mentioned about open doors, and also Casey. First and foremost, as a senior compliance administrator here at FIU Athletics, I cannot begin to tell you how many pitches that I've received to date from several companies who are offering products or services. One thing that Casey mentioned, I think, is interesting, that so many companies are being created. They're focusing on so many things, but I think we all can agree on education is the priority for many compliance personnel. I see Joseph Arnold and Jeff Pullard on the call from Rutgers as well as Dartmouth, and we talk about this all the time. So many areas that NIL addresses: licensing, marketing, branding. But I think the number one priority, and this is just my opinion, the number one priority when any institution should get into to prepare for name, image, likeness should be the educating factor. I think there's a piece of this legislation for the state of Florida that I appreciate, the life skills requirement that is focusing on the financial literacy. Ironically, on the NCAA proposal, you have, it's not necessarily required, only recommended. So I think that's a great piece of the legislation that is required for the state of Florida. And Casey's right. You talk to many of the compliance personnel. Obviously, I talk to colleagues all the time as far as what are we doing? How are we planning to monitor? What are you all doing? Obviously, iron sharpens iron, but the reality is, with everything kind of being up in the air, with the NCAA pausing, I'm sure Casey and Blake have seen the same thing. Many institutions are doing the same thing. So we are not as quick to pull the trigger as it relates to partnering up with many companies. Along with that, I can tell you from my experience, what I've done, I've created a working group, a name, image, likeness working group. One thing, although we're not able to, make an agreement because we don't know what the NCAA is going to do or what their decisions and guidelines will entail, one thing we can agree on, that this is coming at some point in time. The train is coming, and we need to prepare at some point to protect our student athletes, as they will be able to monetize using their name, image, and likeness.
Yeah, here. I second all of that in terms of education.
I'm on board with that also.
Keone, I know you have to go real soon, so is there anything else you want to add before you have to sign off?
No, Josh, let me just say this to you and the panelists. I just say thank you all very much for pushing this agenda, this message out. The reality of it is Florida's going to lead the way in a few months. We just have to have some parameters in place to make sure that our student athletes are not taken advantage of. And Kevin said earlier, the best, education ought to be our number one aim here. And it must be our number one aim. But again, one of the things we heard also is there's going to be a task force appointed as part of this name, image, and likeness committee in Tallahassee that we're going to be looking at best practices. We're going to be learning as we go. So if I can be of any assistance, I'll put my information into the chat room and you can share my information, Josh. But thank you all very much. And guys, if you need me for anything, I'm here and I just loved it. Thank you.
Appreciate having you.
Thank you. Okay.
Talking about Florida's bill, so Florida's NIL bill specifically prohibits student athletes from entering into contracts that materially conflict with their team's contracts. For instance, if the university is sponsored by Gatorade, a student athlete can't go do a sponsorship deal with Powerade. In addition, the NCAA has proposed that if players are going to do their own endorsement deals, they can't use the school logos. How do you see this playing out, and what would be a fair and equitable solution?
If I can jump in here, I know there's a couple of different things. It's funny with Keone, I'm glad we got to have him on. I mean, that is something to see somebody that's in the room working on the bill and working through it. And I think legacy is what Keone gets to look back on and say that this is a legacy type opportunity for him, as well as any legislator that's worked on this. But it also creates a complexity, right? And as with any big change, I just know that that's what's happened with Kevin. You're talking about people pitching you and things coming to the table. Man, it's exciting, but it is $1 billion market that's popping up overnight, and is going to create a lot of economic opportunities for a lot of individuals, most certainly the student athletes, and it's got to be that way. So I just wanted to emphasize that. That's great to have him on. And I've got some comments, but I don't want to hog too much about the fairness in the NIL bill and the concept of NIL use of school marks and competition. So I'll jump out and let Casey or Kevin jump in on that.
Kevin, do you want to go ahead? Because I have some thoughts on it, but
I'll let you go ahead. Of course, I have plenty of thoughts, but I'm going to keep jump on.
all right. So I think I mentioned, my background came from the professional sports world. And when I think about this new NIL landscape or this new NIL era, and you think about, all right, how is this going to work out in the market? So what are the economic considerations to consider on the other side? So the buyers, right? Brands, licensing companies like Fanatics or Panini. Fanatics does jerseys, Panini does trading cards, EA, video game maker, bobblehead makers, t-shirt makers. And then you think about like sponsorships, right? Visa, Microsoft, Pepsi, all these big brands, Progressive, you see the Baker commercials. Again, just hearkening back to my past life, at the NFLPA, we controlled the NFL player rights. We didn't control the shield, the NFL shield. We didn't control the Miami Dolphins logo. We didn't control any of the team marks, right? So there's a separation of IP. I can tell you from experience, from talking to brands, that it is significantly less valuable to brands, whether it's licensing or sponsorship, to pay for the player rights, the NIL player rights, without the marks, and vice versa, right? So the easy example is, think about video games. Think about it. Think about a sports game that only has the players but doesn't have the team logos. Okay, now flip it. It has the team logos, but it doesn't have the players in it. Neither of those products are ideal. And we could absolutely debate which side is more valuable. And I think, frankly, I think the athlete side is probably more valuable in certain contexts, maybe not all, but in any event, I think everybody agrees that there's going to be more value if the IP is together, right? So starting with that as a premise, meaning the brands and then passing along to the consumers, the next step is, okay, can the pie get bigger such that the schools who hold the marks, their IP, don't lose money? Meaning, if there's $1 today that the schools are making from their corporate partners, if the student athlete goes out and does an NIL deal, whether it's on social or whether it's an appearance, whether it's a billboard, and they get paid a quarter, 25 cents, is the school left with 75 cents, or does the pie get bigger such that at some point you get over $1.25, meaning everybody's making more money? That's the analysis. That's the way I think about this issue. And I look back again at professional sports, and I look at, like, this is 70 years ago, but when when the sports, NFL, the MLB, the NBA, and the NCAA were going to put national broadcasts on, a lot of the owners, the professional sports owners, fought against it. The NCAA fought against it. They said, well, wait a second. If people can watch sports on TV, nobody's going to go to the game. We're going to lose money. Fast forward 70 years, we've all seen what happened with TV. We've seen the astronomical deal that the NFL just cut last week, or just announced last week, of $108 billion over 11 years. The illustration is simply, I'm not saying they're the same thing, but I do think that there's an opportunity to make the pie bigger with brands, bringing in new brands and enhancing the brands that are already in the space of college sports. I don't know if you can get over that $1.25 threshold, meaning are the schools actually going to make more money? But I do know that there's a way to mitigate if the IP is being able to use together, right? So Josh, I got a little off the rules, but the whole point is, like, what is this market going to look like? What are brands going to buy? And I just think, like, I think if you rest on IP, intellectual property law, and you rest on market economics, there's a way to make this work that everybody makes more money.
And here's what I'll say is that one thing, Kev, you talk about a lot of people calling you, in that name, image, and likeness regulation legislation, name, image, likeness is new to college sports. It's not new to sports, all right? Like Casey and I, for the last decade, there are people that this is all they do. This is all they do, is help athletes maximize the value of their NIL rights. That's it. And so there's a lot of upstarts or startups that just show up and say, oh, this is a big market, I'm gonna go after it. But then it's not new to sports. So that's important to talk to those that are in it. And I would say that one of the more fascinating things, I don't think I've talked about this on any panel yet, is that there is Casey, you know this too, there's a difference from your Power 5, $100 million plus a year revenue athletic department and their concerns with NIL, and one that's maybe in the teens in terms of revenue, or less than $50 million in revenue, right? Because I know that there are some athletic directors that are like, hey, if we take a hit, if 25% of our sponsorship revenue goes to our student athletes, all glory. I mean, that's what we want. We want recruiting to happen here. We would rather take a hit as an athletic department and see our student athletes make more money. Others are like, no. We worked our tails off to get this sponsorship revenue. We don't want to fight with our student athletes to see it walk out the door, right? And I think there's this whole spectrum of some institutions look at their student athletes as, yeah, well, if we take less and they make more, that's going to help us with recruiting. Others look at it as like, no, we don't want to compete with our student athletes for sponsorship dollars. And so I guess I don't know if there's, Kevin, I'm putting you in a hard place if I ask you a question of where you stand on that spectrum, but do you understand that that's going to be one of the challenges too, right?
Well, first, like, I will plead the fifth probably. I was listening to Casey talk, and I'm not a big gamer, but I'm going to age myself. One of my favorite games of all time was Coach K on the Sega Genesis. I used to play with the UCLA and O'Bannon brothers, or either them or the UNLV Running Rebels. Obviously, you go to the background, that's what it's all about. I mean, O'Bannon, argued about the name, image, likeness, about being able to monetize using it. But to Casey's point, you talk about the whole branding standpoint of name, image, likeness. One of the things that I present to the working group that I've created here, what partnerships will we need to protect as a group? We know the train is coming for name, image, likeness. The reality is, as a group, as an institution, how can we protect all of our student athletes who will be able to monetize? And another question, I don't know if people want to get into this, and keep in mind, my perspective is coming from a compliance professional. How are we going to align our values with what NIL will allow, will permit student athletes to do? How do we position ourselves for a student athlete who wishes to get into partnership with a CBD company or a marijuana or a company like that. So how are we going to align our, do they align with our values, our behaviors aligning with our vision, mission, and those things? So it's a lot of uncertainties, obviously, as you talk about where we are. And obviously this focus is on the Florida legislation, but obviously where we are, and I'm sure Blake and Casey can understand, with the pause happening, there's so much uncertainty. Unfortunately, there are more questions than we have answers right now.
Yeah, I want to add what, Blake, where are you going to go? Go ahead.
No, go ahead.
So the NCAA's proposal, their latest proposal, for those of you who didn't read it, I know Blake knows it, I know you know it, Kevin, but for those of you who didn't read it, on this topic of, can student athletes do deals with competitors of corporate partners? So the Nike, Adidas example. The NCAA's latest proposal, I thought it was very smart personally, in that each institution got to select its own policy. Two reasons why I think that's a good idea. Number one, what Kevin just said, each institution is different. They're going to have different values. They're going to have different economics. They're going to look at the different categories and they're going to say, well, we could take a hit potentially in this category, take a hit, meaning open it up, but we got to protect these three. And it's going to be different institution by institution. And what it allows for is for each institution to say, okay, we want to recruit around these categories and say, hey, it's open. We can go out and you come here, you can do deals in this category, but in these you can't. That's number one. And number two, I go back to the market is going to dictate, the buyer side market is going to dictate what this overall market looks like for the student athletes and what kind of increase or decrease the schools can see on their revenue side, their for-profit side. So I look at it and I go, okay, each school each year can make a policy and then each on this topic, and then each school each year ensuing year can change it, right? Based on the economics, based on the brands. So it provides this flexibility. I'd be very curious, Blake, to hear your thoughts, but Kevin, from an institutional standpoint, does that, I mean, I'm curious what your thoughts are. Is that a good thing, meaning having the control, or is it better to just have uniformity? You can plead the fifth on this one too, if you want.
No, I think what you have is you will have many institutions when you don't have a uniform policy or uniform guidelines. I'm sure at some point it will come up as if you're looking at potential recruiting advantages, competitive advantages. So in that regard, I think Blake mentioned it earlier, what the coaches are focused on when he meets with them. They're thinking about recruiting and winning. My opinion on that, it varies. Obviously, I would prefer some type of uniform approach to protect, to avoid those discussions. Once again, as I mentioned earlier, you're pulling a lot of compliance officers and staff members away from their core duties. And one of the things we don't want to deal with is having a call or a complaint from a coach and saying, how is another institution able to do this because their policies and procedures are different? So my preference would be to have it uniform.
Yeah, I think that there's a desire. The NCAA and current legislation has this concept of third-party administrator, right? In terms of, so everyone's asking the question, who's going to check if this transaction is allowed against all these rules, right? And one of the things is that the NCAA is mentioned this concept of a third-party administrator, most likely a technology-driven solution, that student athletes must disclose a transaction to this third-party administrator. And I think that a lot of compliance officers, Kevin, are looking at this like, hey, this would be great, right? But you have to understand that most likely that third-party administrator, their number one priority is to check that transaction against the NCAA's legislation, right? Not yours, not your conference. So then it creates this challenge. Well, if you want to have more restrictive rules than the NCAA, then go work and collaborate as a conference so that you're only checking every student athlete in the conference against the conference rules. But maybe, you want to protect your Nike deal and you're an Adidas, or your Adidas deal. And so then you've got a different rule than everyone else in the conference. So then now you've got your own need for a third-party administrator on campus right there at FIU, right? So then if you multiply that out times 1,200 institutions at all levels of the NCAA, I mean, it's going to create this tangled web and mess of 1,200 different legislations to check on one single transaction. which is on a local level, it doesn't seem too challenging. But what I can tell you is from a buyer's perspective, from a marketplace perspective, one of the more challenging things is if you want a nationwide, right, that you're in good hands, field goal challenge, and you want nationwide money to come to every student athlete across the country, but they've got different laws in the state level that they got to navigate. They've got different legislation at the school level, conference level, and the divisional level. And then they've got federal bills. I mean, you're going to see so many of these major advertisers and spenders walk away from it. It isn't easy for them to collaborate with the student athletes. And so that is, the uniformity is important, but the challenge is that each institution is going to want to have their little thing here and there. Right. And I can tell you from just working in pro sports, even though the MLBPA and NFLPA and NBPA, these players associations and unions, they're similar in the way that they do NIL rights. They are all different. And navigating those things with major spenders and sponsors in sports is not easy.
So Casey and Kevin, you guys already mentioned the video game topic. The EA Sports recently announced that they are going to bring back a college football video game. And they said that they will move forward without rosters that include the name, image, and likeness of the players if there isn't some federal law in place in time. But they will license with the universities the logos, the courts, stadiums, and mascots. How do you see this playing out? Like, will this just lead to an inevitable lawsuit? Again, what do you guys think? Like, I know from the NFL Players Association perspective, you guys license as a whole the players' rights to EA, whereas the NCAA doesn't have a union. So how does that work?
Yeah, Kevin, you want to go ahead, or you want me to start?
No, I'll let you take this one.
Okay, well, so I'm going to do my own version of pleading the fifth a little bit on this one, because full disclosure, when I was at the NFLPA as a lawyer up until July, and we redid the Madden deal, and I was the lead negotiator in that deal. And so I know more about EA than I probably want to know, or anybody probably wants to know.
Yeah.
I'll say this generally. Just generally to the last part of your question, Josh, is that the way it works in the professional sports landscape is you've got a single entity, which happens to be the union, doesn't have to be the union, and who gets all these rights, these sets of rights from 2,000 individuals, 2,000 NFL players approximately each year, and they get their publicity rights, their right of publicity, and they sign a piece of paper called the group licensing assignment that says, I'm going to assign you my rights as the exclusive negotiator when it's in a group. In the NFL, it happens to be 6 or more. Other sports have different numbers. Why it's 6, I don't know. My theory was 6 is more than half of the players on one side of the ball. I don't know. I just made that up. But that's how it works in college, or I'm sorry, in professional sports. Blake mentioned the different unions have different numbers, but that's how it works, right? Group licensing, though, doesn't have to be done through a union. Right. It doesn't. There's no legal, business, or causal relationship between group licensing as a concept and unions. And that's one of the misconceptions around this whole debate is, in order to have group licensing, don't we have to have a union? The answer to that is no. However, the concern from the NCAA standpoint, which I understand, is it's a slippery slope, right? The first step, if you have an entity that represents all of the NIL rights of college athletes, well, are they going to start talking about other stuff like, I don't know, collective bargaining and wages an hour and things like that? And that's a perfectly legitimate concern. But in terms of group licensing itself, the way it's done in professional sports doesn't have anything to do with the union. So theoretically, you could imagine a bunch of different ways, and I'm sure Blake has a thought on this. I know he does. There's a bunch of different ways that you could aggregate these rights. All it is, I mean, it's like me going around my neighborhood and saying to all my neighbors, hey, I'm gonna use all of. Can I use your bicycles on Saturday? Each individual, I'm gonna use your bicycle on Saturday. Your bicycle on Saturday. Go down around the block, and then on Saturday, I take all the bicycles and I rent them out. They come back, and I go and I give a check to all my neighbors. That's all it is.
Yeah. Well, I think, Casey, you're hinting at something, that there's technology-driven licensing is something that is available to this market. And I'll just give we have a project at Open Doors called Open Doors Deals. It's our marketplace solution. And there's a way that if if Pepsi wanted to, they can go right now and send an endorsement deal to 13,000 different athletes represented by 1,000 professional athletes represented by 1,000 different agencies. They could hit one button and send out an offer to all of them, and they could all just say yes or no to it, right? And so that same technology is and will exist in the collegiate sports space, and you can aggregate athlete IP at scale using technology. Now, the one of the more so that's the conceptually doing it is going to happen. Like somebody's going to use technology to aggregate student athlete IP rights, right, and allow third parties to license those rights in bulk, right? It's going to happen. One of my favorite debates on this is that when you look at royalty distributions with the NFL Players Inc., all right? So everyone would agree that Patrick Mahomes and Lamar Jackson and Russell Wilson and Derrick Henry and some of these superstars and make the sales of Madden a hell of a lot easier for EA Sports, right? But Patrick Mahomes gets the same percentage royalty of all the sales of Madden as a starting lineman, right? It's split evenly. Casey, you can correct me if I'm wrong on the nuances, but all of it goes into a pool, then everyone splits it, okay? So the starting lineman and Patrick Mahomes get the same amount of money from the sales of Madden. Am I right or wrong on that, Casey?
Yeah, that's right. There's a that's right.
There's some nuances to it, but now
yes, that's right. There's accounting nuances with a nonprofit, but yeah.
But let's bring it into the college landscape. And one of the things is, if you think about let's go back in time. Let's say that the game existed, and Trevor Lawrence is the overused example for NIL. But let's think about Trevor Lawrence or Joey Burrow, and there's no doubt that individual would drive the sales of an EA Sports, college video game, maybe more so than his offensive lineman. And for that reason, Trevor may be in a position of negotiating power, right? Where he would rather not be in a group license because he doesn't want to split the pool with everyone else. He could make $1 million, not 10,000, not 1,000, right? And the only thing that keeps Patrick Mahomes in the Madden video game versus trying to take himself out is because he's in a union, right? Am I wrong on that, Casey? Man,
I disagree with it.
Okay,
I don't want to monopolize.
No, I get.
But y'all remember, and I might be aging myself now. I'm going to talk about video games, Kevin, too. Remember when Michael Jordan wasn't in video games back in the 90s?
Mm-hmm.
Yeah, Michael Jordan. Why? He opted out of group licensing. Michael Jordan said, I am bigger than, my brand is bigger than the collective group of NBA players. Y'all remember the game that he put out? He put out a couple games. He put out one that was some weird action game where he was like throwing basketballs at ghosts. And another one, he was playing basketball, but it was with a bunch of no-name players. They didn't sell. And MJ and Blake left because I'm gonna own him. There he is. But MJ has since come back and said, look, I lost money because of that. So that's one example. The other two examples are the last two holdouts from NFLPA, the group licensing, were Johnny Manziel, and that was a whole nother topic, but LeVar Arrington. And LeVar held out, and it was a pain for everybody. And the argument was, my NIL is going to be more, I can make more not being part of the group. And he made significantly less. I'm not going to get into the numbers, but he made significantly less. So I think it's a matter of economics. I think there's a premium on the collective when you think about a video game. Not true for jerseys, not true for bobbleheads, not true for other things, right. But for video games specifically, I think there's a premium on having every single player in it. And that's the philosophy behind the equal split.
Josh, when you asked the question, I had already decided I was not going to touch EA Sports. However, as Blake and Casey were discussing, I'm actually was messaging some colleagues, and it goes back to my original statement when we first started talking about name, image, likeness. The one concern that I have from a compliance standpoint, who's monitoring it? How will we monitor the splinter groups, the student athletes? Obviously, they're not using names, but it still becomes a monitoring concern from my office.
This is my last question before I want to open it up to the floor for Q&A. But Kevin, like you mentioned before, like the concern about certain deals, whether it's CBD, marijuana, but Also, for our panel tomorrow is about the future of sports betting and gambling in Florida. So some sports betting operators have partnered with colleges such as the University of Colorado and UNLV, yet college athletic departments are telling players they can't wager on games, and college athletes aren't seeing any of the betting revenue that's being generated. Right now, March Madness is going on, hundreds of millions of dollars are being bet on these college athletes, yet they see none of that in return. Will college athletes eventually have the ability to use their own name, image, and likeness with sportsbook partnerships? Or like, what is the concern that if athletic departments can do it, why can't athletes do it?
Well, I believe, and this is my opinion, I think once the name, image, likeness legislation is figured out, and first and foremost, I think once we have it and it's in place, I think it's going to take a year or two for us to really figure out how it works, what's not working, and really look at some areas of opportunity. Getting into sports wagering, sports betting, I seriously think that is the next area that will be addressed through state legislation, which will force the NCAA to make some decisions down the line. So to your point, I do think that it will be up for discussion. I just don't know what it will look like. So I hope that answers your question.
Yeah. Casey, remember that when PA, we couldn't do alcohol deals, right?
Yeah.
Yeah, but now with Bud Light's on the table, right? Anheuser-Busch.
Correct.
And so what I'm talking about for the,
Theoretically, like all the partners are, but we know who pays the check to the league, so we know who is actually on the table.
Yeah, all alcohol brands. I know. So what I'm talking about as a reference to the audience is that for years, the NFL Players Association, NFL Players Inc., did not allow athletes to, let alcohol brands, namely beer companies, use their name, image, likeness, and promotional materials or assets. Now the league could. So you always saw the official beer of the NFL, but never the players were actually promoting or supporting those sponsors. That has changed, and I think that's a market economics decision. I mean, the amount of money that Anheuser-Busch was spending on corporate sponsorship, it would be foolish for the NFL Players Inc. not to allow those athletes to at least participate in some of that upside of that spend. And so I think that is what is going to drive most of these changes around who student athletes can or cannot endorse or promote will be the spending factors and economics in the market, right? So if MGM becomes the sponsor of every college athletic department in this country, then it would probably make sense for the student athletes to at least be able to participate in that. And I think that is what is going to be a driving factor and force. But in the beginning, the NCAA's current proposed legislation does specifically mention sports wagering and banned substances are two category types that student athletes will not be allowed to promote, right? So they're saying on an individual level, campuses can have their own policies. If a sponsor cannot be an official sponsor of an NCAA tournament event, a championship event, then a student athlete also cannot promote that type of entity. And sports wagering and banned substances fall into that category currently.
Thank you, Kevin, Casey, and Blake. We have a few minutes now for the audience. If you guys want to, if you click on the participants and raise your hand feature, I can call on you. I see Khalil.
Yes, want to thank the panel. Thank you guys for this. Very interesting. I learned a lot today, so thank you for taking the time out of your day. My question had to do with if athletes will start making money off their name, image, and likeness, do you think that will open the floodgates for schools to start advocating and saying, look, we need to be more competitive in our recruiting process. These athletes can go anywhere and make great money just off their name, image, and likeness. Do you think schools will start advocating to be able to start giving athletes bonuses or incentives, money incentives for them to start coming to their schools?
So I'll jump in. Here's the thing as the proposal is written down. I'm going to address it as a proposal because it has not been voted on yet. I saw a coach, I won't say the name, but I saw a coach on social media over the last week or two talk about possibly arranging some name, image, likeness, some benefits for current student athletes and potential prospective student athletes I don't think that's what he meant. However, I think that's how it was delivered. As it's written now, NCAA does not permit any institutional staff member to be a part of such arrangement. I'm going to keep going back to the monitoring aspect, because how do you monitor it? The proposal also has 4 prongs. You're looking at current student athletes, prospective student athletes, you have your professional service providers, and then there's the disclosure, which Casey and Blake mentioned as well. So from an institutional standpoint, and I'm hoping I'm answering your question, but how do we address the elephant in the room? There can't be any arrangement from a staff member or anybody affiliated to the university. One of the things that we have not mentioned yet, and which concerns me heavily, booster involvement. Anybody associated to an institution, how are we going to be able to monitor it? Because obviously moving forward, once this comes into play, you obviously are permitting there to be a level of legitimate booster involvement. How are we going to monitor that? How are we going to educate not just our current student athletes, but you're looking at faculty, staff, individuals associated with prospects, ultimately boosters. So a lot of things come into play as you talk about the arrangements of possible, the overall recruiting spectrum.
Real quick on this, Khalil, the way to think about this is that from a institutional involvement, this is no doubt going to be a recruiting battle the next decade, right? Who has the best name, image, and likeness opportunities? And once the dollars are known, it's going to be publicly, like this will be bragged about, right? Athletes at this school make more money than athletes at that school. It's going to be talked about. It's like attendance records, right? But the school themselves can't technically be involved with it. But schools are investing heavily in name, image, and likeness rights solutions, like partnerships with, when Texas partnered with KC Schwab and Altius, that is in every recruiting deck they have, right? When Florida partnered with Open Doors, right? Florida talks about Open Doors as their partner in NIL. It is like having a jumbotron that's bigger than everyone else's. It's like having a bigger weight room, right? So it's a recruiting battle already. The schools just simply cannot be involved in the dollar flow, but they can be involved in helping the athletes prepare for it.
Thank you. Thank you. Appreciate that.
Mm-hmm. Shakina, we can just go down the list.
Yeah, hi, my name is Shekinah. Yeah, my question is, I guess for the panelists, have you heard any discussion or anything about any of the student athletes looking at this new emerging market of NFTs, the non-fungible tokens? Because we know that with Gronk, Rob Gronkowski just did some digital trading cards. We know that what is it? Patrick Mahomes, I believe, just released his own as well. And we heard about NBA Top Shots. Have you heard anything or any rumblings of college students, athletes thinking about, hey, I want to get into this as well?
My favorite topic.
It's got to be, Casey. Yeah, talk about it, man.
I love this. So I'm just going to go on record, and this is being recorded. No joke. And Blake knows this. 2018. I swear, there's an article out there that 2018, I was at the PA, and I swear to you, we set up a meeting with the NFL, and we were like, digital collectibles, crypto collectibles, we've got to get into this. The NFL, and they were like, no, we don't want to be first. We don't want to be first. That was almost 3 years ago, and they missed it. They totally missed the boat. Now they're out there, like, it's crazy to me. Every time I see a headline, I feel a little pain in my stomach. But in terms of your question about college student athletes, this goes to my point earlier about new and emerging categories and the value of intellectual property. All right. So like, think about, so I saw Gronk didn't have a deal with the Pats or the Bucks or the league. Right. And he pushed it a little bit, I think.
Yeah, he did. That looks like IP. That looks like the uniform. I mean,
know.
Yeah.
And I'm no longer there, but I can almost guarantee you that there are discussions being had with his marketing rep who's a bulldog, as Blake knows, and the league about that trade dress, right? Trade dress is like a part of IP of the jerseys. So it goes back to that. Second one is think about highlights. Now we're not talking about trademarks. We're talking about copyright. We're talking about copyrighted, extremely valuable copyrighted material. Who owns the copyright? Well, that depends on the school and the conference. Usually it's the conference, and they have deals with companies that go out and they license the archival footage. It's not easy is the point. because now you're getting away from trademark, which is complicated enough, and you're getting into copyright law. So when I think about NFTs, I think there's a huge opportunity, but I think it comes down to making sure that the rights are licensed the correct way. And again, there's a lot of lawyers on here, so you'll appreciate the difference between trademark and copyright, and making sure that if you're going to go out and license for an NFT, basically a digital trading card is what it is, or a digital highlight on a trading card, that's a 1 of 1 or a 1 of 5 or 1 of 10, you better make sure that you're checking the right boxes to make sure everybody along the way is getting paid.
Yeah. Yeah. The photographer that took the photo, right. And anyone else that's involved in the production process. I think one of the things about the NFTs and that market is it brings to this concept of market value is of importance in terms of determining are there bad actors or malfeasance in the student athlete name, image, and likeness market. All right. And what I mean by that is that, if a student athlete at FIU is, let's say that the quarterback for the Dolphins, Tua, right? Tua gets an appearance deal for $10,000 for 1 hour, right? The starting quarterback for the Miami Dolphins. And then the starting quarterback for FIU gets a $20,000 appearance deal. Everybody's kind of going to scratch their head and say, that's interesting. Why is a FIU kid? But maybe it was rumored that he's going to enter the transfer portal, right? And that local dealership is like, hey, I don't want that kid to go anywhere else. So I'm going to get him a deal. I'm going to pay him twice what we just paid Tua last weekend, right? So that's going to make everyone scratch their head, because then is this a pay for play scheme, an inducement to have somebody stay or attend a certain university? And those are the things that the NCAA and the whole NIL third-party administrator is going to try and figure that out from a compliance standpoint. But you have a market. If the FIU kid puts an NFT online and it sells for $100,000, well, hell, maybe that's the market. We don't know, right? Because it's just never been done. I think that's the thing that's going to be really complex is trying to determine, is this market? And everyone always says market is what people are willing to pay for something. Right? And that is also true. But if NFTs become cigarettes in a prison yard type stuff, right, where it's a trading mechanism for keeping kids at your school, that's going to mess up college athletics. So what is good and what is bad is still to be determined, and new monetization mechanisms like NFTs are going to make everyone in Indianapolis scratch their heads.
Blake, I just want to thank you for adding to my list of concerns with that one response.
Yeah. Hey, that's Shekinah right there. That's who you got. That's on her.
Shay, you can ask your question now.
Perfect. Hi, guys. I wanted to say thank you so much to the panel as well. I guess this question is directed to Kevin. This might be adding another list to your concerns. I know Blake is also a former player. Now that we've basically established that name, image, and likeness is the future of college sports, what recourse or outlash do you see from the tens of thousands of former college athletes out there who didn't get a chance to get a piece of this pie? Like, do you see liability on the NCAA? Do you see litigation going to the schools for not being able to endorse them? What recourse or what action do you see from that massive group of athletes?
Not necessarily, because here's what happened. I talked about the situation with, I can't think of his name, the basketball player with UConn several years ago when they won the championship. The comment he made indicated that he had gone hungry for so many nights he, couldn't eat. Now, all of a sudden, since that comment, which sparked so much outrage, you saw several pieces of legislation come into effect. Student athletes were able to have meals incidental with participation. Reasonable snacks legislation was modified. They added the cost of attendance. Shabazz Napier, thanks, Jeff. One of my good friends who oversees compliance at Rutgers, thanks a lot. You saw a lot of legislation change that addressed that specific comment. In addition, there was a lawsuit that was passed which allowed former student athletes, I can't think of the ranges of the year, but several student athletes that participated in FBS football and men's and women's basketball were compensated due to the decision that was made on this specific lawsuit. I can't think of the case, but do I think that there will be some backlash? Not necessarily. I think you will have one or two from many institutions who may have received, or could have, but I think overall there were some, I don't think you will expect too much backlash.
I think that that's one of the hidden parts about this Alston case, guys. Honestly, is that the NCAA is trying to get to a point. You hear about safe harbor or antitrust. Some of those common terms that you're hearing around this, is that when the NCAA has made reform to modernize legislation, right, to help athletes get unlimited bagels or snacks or whatever, right, the stuff that I didn't get in Nebraska, but now they get whatever you want, is that when they do that, they get a class action lawsuit from everyone else that missed the boat, okay? And they're gonna, if they don't get protection, every time the NCAA tries to be better, okay, we all want them to try to be better. Everyone here does. The NCAA does. I mean, the NCAA is a membership group too, right? Like, so it's not this wheezy, woozy, fugazi thing. Like, it's every person you ever know that's employed in college athletics, they are the NCAA. Kevin, you're the NCAA, right? You get what I'm saying? Like, it's all a membership group. They're trying to get better. But when they get better, they get blasted with a lawsuit that disrupts the entire mechanism. So what you're trying to see is that there's like, when we make reform, we do not want to open ourselves up for litigation for everyone that didn't get a part of this in the past. And that's something you got to like think about from a legal standpoint. If the NCAA was your client, you'd probably want that too.
Does anyone else have any other questions?
Josh, may I ask a question?
Of course.
Kevin, how are you doing?
I'm fine, Dr. Bardo. How are you?
I'm good.
Good.
What is this NIL legislation going to do to HBCUs, for example? Is this legislation not going to increase the disparity between the haves and the have-nots?
I'll hop in first. So I'm an adjunct at Howard here in DC, Howard Law School. It's a great question. I actually don't think it's going to increase the disparity between the haves and have-nots. I think it's going to create a new disparity for the folks who lean into their own narrative, meaning more specifically, the HBCUs, and Kevin, you may have been referencing him before, Coach Prime down at Jackson State. Like, I think I saw that video.
Oh yeah.
I used to work with Prime at NFL Network. He's a great guy, but like, it's always like, but anyway, Dr. Bardo, to your question, like Coach Prime, like you can rein him in a little bit. What a great way to have a mentor who's made all these deals, and he's a marketing savant, man. He created the athlete influencer long before social media. So or here Howard here in DC has such a robust alumni group. And again, there has to be guardrails around what the alumni, what the boosters, what the partners can be doing and what they're paying for. So they're not paying for inducements for recruiting, they're paying for NIL. But the robust alumni group of Howard here in DC, like I'm telling you, it's stronger than Georgetown, it's stronger than GW. No offense to anybody who went to those schools, but like, I think if HBCUs embrace this, no different than the blue chip schools, the Power 5 schools, no different than the mid-majors that happen to be in smaller markets. I think the key is saying, okay, what can we identify that's unique about us? And then how do we build around that? Blake mentioned attendance rates and graduation rates. It's no different, even simpler. Like, if you have a beautiful campus, I'm a UW-Madison undergrad, beautiful campus. You know, they recruit around that. The lakes, it's a beautiful place. No different than that. If you're recruiting around the objective facts of your uniqueness of your school, leaning into it, then I think this can be a really good thing for HBCUs. I really do.
I would agree 100%. I think what you'll see at the HBCU, obviously, perfect example. I did reference him. I didn't mention his name, but I think he's definitely a marketer. He's doing a great job putting Jackson State in a position to secure some agreements down the line. Some people may question the method, but I think he's doing a great job as a product of an HBCU. I think it's a great way to really analyze and look at many lower resource institutions to see how, this is an opportunity to really look at how can we get creative. Obviously, you don't have the resources as a Florida, Georgia, Texas, and so on, but I think you'll see many creative avenues taken, such as the one that Coach Prime. Now, there can only be one prime time, but I think this is a good opportunity that, that he's taken full advantage on, and ultimately he's taking he's shouldering the responsibility of many HBCUs. I mean, he's openly admitted to that.
Look at Vice President Harris. Like, she's a Howard alum, right? Like, she can open doors. She can connect. Open doors. There, I gave you a promotion there. Like,
Open doors for you. There
she
you
can
go.
open doors for these these Howard student athletes. Like, there's so many that it's not just the Coach Primes, prime times. It's folks in sports. I think it's the robust networks that these HBCUs have that they care passionately and deeply about their students and their student athletes, obviously.
Definitely.
Eddie, you can ask the last question and we'll sign off here.
Thank you, Josh. I, again, want to relay the sentiment. Thank you all so much for sharing your time and your advice and opinions. My question's about sanctions for NIL. So it might be directed at Mr. Kendrick, but I welcome any advice or opinions on it. When NIL does become implemented and there are sanctions, both individual and program wide, what do you feel is going to be the most appropriate? Because now that we have money in place, is it going to become a fine system, or is it going to continue to be suspension based?
Simply put, I do not know. And that's one of my concerns. That's why, as a compliance professional, I am very nervous. As I mentioned earlier, when I'm thinking about disclosure and this whole thing of name, image, likeness, there seems to be so much uncertainty, primarily surrounding the monitoring, the enforcement. Will it be an institutional violation? Will it be a student athlete who potentially participates while ineligible? How are we going to handle a student athlete who does not disclose an agreement? As it's written now, student athletes have to disclose all agreements within 14 days, I believe. What if that doesn't happen? What if a student athlete exceeds the 14 days and forgets? How are we going to really hone in and really self-report? What's the requirement? How does the NCAA feel about us, finding out after the season? There's so many different avenues this thing could take. And I wish I had a better answer for you, but the reality is, with everything on a pause from an NCAA level, I'm unable to give specific information as it relates to what it will actually look like moving forward.
Yep.
So many questions and so much uncertainty. I simply don't know.
Yeah, I would say that there's going to be an emphasis on, if the institution is being malicious with their intents, right? That it's very easy to say that that's an institutional, issue. And then if the student athlete is being intentionally malfeasant and their disclosure or not disclosing what they need to, like, they could be in trouble. One of the more interesting things is that the current NCAA legislation, I'm going to throw this out there as something I don't know anyone's thinking about, is that it requires every institution to make their policies known publicly. So, like, there are 1,200 NCAA institutions, and on every single one of their home pages on their athletic website, there's got to be a link starting this year that says, here's our NIL policies. And, like, somebody's got to make that easy for all these schools to do. I just think, like, there's an economic opportunity. Somebody's going to do that, right? And then it's got to be updated. So if they change the rules at FIU, if Kevin changes a rule, then that's got to be up there on the site right away. And then if they don't do that and something happens, then who's in trouble? I just, all these different things that you can see who it falls on a lot of times. I think one of the more interesting things is what happens if an athlete gets paid $1,000 cash, right, for an autograph that maybe he signed while he was wearing FIU gear, okay? And it comes out later that he was wearing institutional marks when he signed the autograph. And so that now him, by accepting that payment, it's an impermissible transaction. Well, he's already spent that $1,000, or he already sent it home to his family, right? So now to rid him of the burden of accepting payment for an uncompliant transaction, he's got to now give the $1,000 back. but the person who got the autograph already got the autograph, right? So does he have to get the autograph back? I mean, these are the things that it's going to create a lot of nuances for everybody involved, and nobody knows the answer to those questions yet.
Agreed, 100%.
Thank you all so much for taking the time to speak with us today, Kevin, Casey, Blake. We really appreciate it. Definitely learned a ton today. Couldn't thank you more for being part of the first Symposium at FIU.
Josh, let me thank you for moderating such a great event. Casey, Blake, thank you for sharing this space with me. I personally want to send a thank you to Julie and Heath, senior associate athletic directors and chief operating officers for FIU athletics, for allowing me to have this space as well. So thank you to you all as well. Iris Elijah, who partners with me, kind of gives me a lot of information for the Florida legislation. She's our associate general counsel, so thank you as well. So I think this was a great event, great information, and looking forward to working more with all of you individuals as well, moving forward.
Lots more to come. Thank you, everybody. Thanks for having us.
Yeah, thanks, Josh. You guys be good.
Thanks, everybody.